I begin on time. Thank you for coming. Chairman Dunn of the Town Council asked me to coordinate this training with the Hampshire Municipal Association. Just make sure everybody's familiar with that, make sure we don't want to follow those. And the best way to do that is to make sure everybody understands what the rules are. So here what we have today is we have staff members who are liaisons to boards and committees. We also have staff members that deal with 91A requests. And then we have members of our boards, various boards and committees here tonight. And Jonathan Cowell, he's an attorney for NHMA. I'll let him introduce himself with further detail, but he's going to go over that. You should have received the PowerPoint presentation already. We're going to record this so it'll be available for people who could not be here tonight, as well as new folks coming in. There's a sign-in sheet. If you would, just print your name and what department or what board or committee that you're on. That would be helpful so we know who is here. And you'll have opportunities to ask questions here as we go along. And without further ado, I'll turn it over to Jonathan.
Thank you, Sean. Good evening, everybody. My name is Jonathan Cowell. I'm the Legal Services Counsel at the New Hampshire Municipal Association. So if any of you are not familiar with NHMA, just a very quick overview. We are a nonprofit member-based organization, which means that every year, every city and town has the choice whether or not they want to be a member of NHMA. And luckily, again, in 2026, all 234 cities and towns are members. So that means that you all are members of NHMA, and with that comes access to all of the resources that we offer. So there are a few different things that NHMA does. We go out to municipalities and do these type of on-demand trainings. We present many different trainings in our offices in Concord throughout the year, which you can take a look at on our website. And we offer our members access to our legal advisory service. So our legal advisory service is made up of two attorneys, myself and attorney Christine Johnson. We're available Monday through Friday, 8:30 a.m. to 4:30 p.m. You can reach us by email or by phone. I personally think that legal advice lives its best life in writing. So I think email is the ideal way to get your legal advice. But if you have a question that you just want clarification on something, feel free to give us a call, and usually someone's available to take your phone call. We provide all different types of general municipal legal advice. When it comes to RSA 91A and the right to know law, those type of questions we can answer. We get them all the time. It's one of our most commonly asked areas of the law that we get questions on, and we can always help you work through those issues. You'll see today, hopefully it won't feel too overwhelming, but there are aspects of RSA 91A, especially when it comes to record production, that can feel complicated. It can feel like bogged down in some of the legal language we're going to go over. And if you ever have trouble applying some of these tests that we're going to talk about, feel free to contact us. There are a few things that we can't help with, like settling intra-municipal disputes within the municipality, since we represent the municipality as a whole. And right now we can't help with actually drafting policies or ordinances, but we can give you the resources to help you on your way to doing that. So feel free to contact us anytime with legal questions, and we can usually get back to you, usually the same day, but up to 48 hours if we're busy with our conferences or something like that. We have a series of publications that are also available free to our members. In order to have access to the free version, you have to have a login to our portal, which somebody in your department should know how to access, or someone in town will have access to that. And through our portal, you can have free access to all of our publications. We have one that we update regularly on the right to know law. Every year we do an update or a supplement to cover any changes that happen via case law or via the legislature. So everything that I'm going to talk to you about today is covered in our publication and in great detail. And there's some good appendices in the back of that where we give some sample policy language. We just did this year a pretty big update to a supplement specifically for law enforcement. I think that law enforcement agencies probably get hit the hardest when it comes to right to know records requests, and those records are generally the most complicated to analyze and deal with. So we took what was a one-page guidance document and turned it into about 7 pages to deal with some of the more complicated law enforcement issues. So that's also available on our website. For today's training, I'm going to go over, there are sort of two distinct parts to RSA 91A. There's the first sort of half of the chapter, which deals with the rules related to public meetings. And so the first couple sections of RSA 91A talk about how to hold a proper public meeting, when you have to take minutes, when you have to have things open to the public, what constitutes a non-meeting or not a meeting at all, when you need to make sure that you have a quorum present before you make any decisions or engage in any discussions. That's the first piece of RSA 91A, and that's the first part that we're going to go over today. And then in the second half, I'm going to get into RSA 91A as it pertains to records, how to handle right-to-know requests, what some of the exemptions are that you might find when you're looking at records, deciding whether or not to disclose them, and then the timetables and violations that might occur if you don't stick to those timetables when it comes to producing records. As I go through this presentation, feel free to interrupt if you have a question, raise your hand. Definitely, if something comes up that you don't understand or you have something you want clarified, please don't hesitate to ask. So to start, we're going to talk about how the right to know law governs meetings. And to understand how RSA 91A, and so RSA 91A is the chapter, that's the section of laws. It's RSA 91A:1 all the way through, I think, 11. That deals with these laws, and we call RSA 91A the right to know law. That's sort of what it's been nicknamed as time has gone on. And so to understand how RSA 91A and the right to know law governs public meetings, first you have to know what is a meeting. There's sort of three different types of gatherings that can occur. There's a meeting, there's a non-meeting, something that doesn't constitute a meeting at all, and there's also non-public sessions, which sometimes can be confused as being not a meeting, but it is a meeting. A non-public session occurs within a public meeting. So understanding the differences between a meeting, a non-public session within a meeting, and a non-meeting is important. And also holding meetings virtually. So now it seems like it was longer ago than it was, but we did at one point have special rules in place during the COVID-19 pandemic where portions of RSA 91A were suspended, which allowed for more access to virtual meetings. All of those emergency orders that were in place at one point have now ended, and we're back to the standard RSA 91A that we've lived with for a while, and it has yet to be substantially updated when it comes to the virtual meeting aspects by the legislature. So we are still living in a world where all public meetings must have an in-person quorum, and there are very few exceptions to that. But there is an avenue within the law to allow an optional allowance of one or more members of a public body to attend virtually, but there's specific rules that you need to follow to make sure that you're doing that properly. So we're going to go over that as well. But to understand what is and isn't a meeting, we have to look at the definition of what a meeting actually is. And so RSA 91A:2 gives us the definition of what a meeting is. And the way that we break this down is I like to look at it as elements. So there are 4 elements. In the law, in order to prove something, before I was an attorney here, I was a prosecutor. And so whenever I wanted to prove that somebody did something, I had to prove every element. If I missed an element, then I didn't prove my case. It didn't happen. So I look at meetings the same way under RSA 91A. There are 4 elements that you need to satisfy in order to have a meeting under RSA 91A. And if you're missing one of these elements, then that means you don't have a meeting, and that means you shouldn't be doing anything that needs to be done at or in a meeting, unless you have these elements present. And so what they break down to is a quorum of a public body convening so that they can communicate contemporaneously to discuss or act upon something over which that body has supervision, control, jurisdiction, or advisory power. So these may seem self-explanatory. The last 2 are the more complicated, but we're going to go through all of them because to understand what a meeting is, there are some intricacies to each of these elements. So to start, we have a quorum. That's usually the most straightforward one. A quorum means a majority. It means a majority of the membership of the public body. Sometimes another statute may apply. It's rare, but there are some instances where another statute might affect what your quorum numbers are. One of the most common examples with that is the ZBA. And so a ZBA is always going to be made up of 5 members. A quorum is going to be 3 out of those 5 members in order to hold a public hearing, for example, on the granting of a variance. you could hold a public meeting with only 3 members present. That's still a quorum of 5. 3 is a majority of 5. But where another statute comes into play is that the law says that you, as members of the ZBA, you always have to have 3 yes votes in order for anything to pass. So in order for a 3-person ZBA holding a public meeting to pass a vote on a variance, for example, they don't need 2 out of 3 as the normal majority would be. They need 3 out of 3. That's where another statute might apply. But for the most part, your quorum is going to be covered by meeting the majority of your membership. The other question we get on this on occasion, where it can get a little bit complicated, and this is one of those wonderful topics where you can ask 3 different lawyers and get 3 different answers. So I'm going to give you what I think is the safest advice, and it's what I would recommend following, but it may not always work in every situation. And what I'm talking about is when you have a larger public body, let's say your planning board of 7 members, and you have vacancies on that public body that haven't been filled. So a planning board is supposed to have, let's say, seven members. You have a 7-member planning board. But if you have 3 empty seats on that planning board because you haven't been able to find anybody who wants to serve in those positions. It's a problem that a lot of the smaller towns run into. Well, now you only have 4 members of your planning board. You have a quorum. 4 out of 7 is still a quorum, but you only have those 4 members. So every single meeting, you're going to need to have all of those members present in order to hold that meeting. And sometimes we get these questions where, well, what if we're missing 1 person? Our board is currently only filled to 4 out of the 7. Can we then have 3 out of the 4 and be okay and still hold our meeting? And the answer to that is that when you have a statute that tells you what the size of your board must be, like a 7-member planning board or a 3 or 5-member select board, that's the number that you have to operate under. And the statutes expect that vacancies are to be filled immediately or as soon as possible. And so we always recommend using the bigger number when you're counting for your quorum. If that's not possible, then you could still go forward with a quorum based on the amount of people you actually have serving on that board. But you need to do so understanding that decisions that you made may be subject to appeal. We've never seen it happen, but there could be an argument that a decision isn't valid because you didn't have enough members present. Yep.
So if in statute there's a flexibility about numbers, does that give you a flexibility about quorum, or should you still consider
It could.
with the
It could, but in most cases, when there's a flexibility of numbers or a range that you can choose from, it's decided in some sort of definitive way, usually by a vote of the legislative body. Your town meeting decides if they want a 3 or a 5-person select board, for example. So when you have especially something that's been voted on and established by a vote of town meeting, that's really the number you have to work off of. Where you could get away with this more easily is when you have something like an advisory committee or an ad hoc committee where, let's say, your select board creates an advisory committee of 7 members to help with planning the 4th of July parade or something like that. Well, your select board just chose that number 7 that they wanted to seat on the committee, and if you lost interest by some individuals and they dropped out and you had vacancies, that would be the type of committee you'd be much safer adjusting your quorum numbers based on who's actually filling the seats versus something like a statutorily defined committee or one that was voted on.
Thank you.
So public body. So we have a quorum. The next element that we need to meet is a public body. And so all of the standard public bodies that come to mind, your select board, all of your land use boards, your budget committee, your unofficial budget committee, your heritage commission, your library trustees, your trustees of trust funds, these are all public bodies. Any of those public bodies that have they have a statute that tells them what their powers are and what their numbers are to be and what their membership is going to be. Those are all public bodies for all intents and purposes. They're always going to be considered a public body under RSA 91A. Where it gets most often misunderstood by municipalities is when we get to smaller subcommittees or advisory committees. So every once in a while we hear, well, our board, let's say our library trustees decided to make an advisory committee to help talk about what type of programs we want to run over the summer for the kids at the library. And they appointed 3 people to this advisory committee, and these advisory committees always like to attach a name to what they do, and they call it like a work session or a fact-finding session. And what we hear these municipalities say is, well, these advisory committees don't make any decisions, they don't take any votes, they don't do anything other than gather information together, and then they bring it to the library trustees or to the select board, and they present their findings during a public meeting. So when they meet, all 3 of them, this advisory committee for the summer program at the library, when all 3 of them meet, that's not a meeting. They don't qualify under RSA 91A, and that's unfortunately an incorrect understanding of the definition in RSA 91A, because it specifically says that even if the only role of an advisory committee is to advise the larger public body, they are still a public body under RSA 91A, which means that when they meet for their fact-finding sessions or their information gathering sessions, they're going to need to meet the criteria of a public meeting under RSA 91A, which is a public place, notice, and minutes taken, which we'll get to a little bit later on. An example of something that isn't an advisor or a public body, we have a good example from a recent case. A committee of city employees that provide advice to planning board applicants is not a public body, and so that was from Martin versus Rochester. And what happened here was a group of city employees on their own. They weren't tasked to do this by the planning board. They weren't instructed to do this by any government entity or any other public body. They chose on their own to create this sort of advisory committee to help other members of the municipality navigate applying before the planning board for a particular submitting applications. And they did this because they had some knowledge of how the system worked from their positions in the municipality, but it was really private citizens choosing to do something on their own. And they weren't advising the planning board in any specific capacity. And most importantly, they weren't tasked to do this by any government entity. So the court found that they weren't a public body for the purposes of RSA 91A. Another example you might see is I know in certain towns you might get like a Facebook group of people that call themselves, the Londonderry such and such committee. And what it is really just private citizens who are meeting on their own, not instructed by the town, discussing certain issues, and then maybe they show up at the select board meeting during the public comment period, and they say, we are members of the such and such committee. They can call themselves whatever they want, and that's fine. They aren't a public body under RSA 91A because they weren't recognized or appointed by the select board or by another government entity. It's just private citizens choosing to do something on their own. Yep, question in the back?
So, should subcommittees post their meetings, in your opinion?
Yeah, they have to. Subcommittees have to post their meetings under RSA 91A. And for the most part, it's going to be the absolute bare minimum notice, which is 24 hours posted in 2 public places, one of which can be on your website. But all subcommittees, all advisory committees, any group of individuals that are appointed or created by another public body in town are considered a public body under RSA 91A and has to meet those requirements that we're going to talk about. So, moving on to sort of the third element, which is contemporaneous communication among members of a public body. So when you have a quorum of a public body convening so that all members are able to communicate with each other contemporaneously, what does that look like? And so ideally, you want that to always look like an in-person communication during a properly noticed public meeting. Where we run into problems on occasion is when we have members of a public body communicating with each other back and forth through some type of electronic communication outside of a public meeting. And that's where we can get into some sort of difficult or sticky situations with potential violations of RSA 91A when you have discussions taking place outside of properly noticed meetings. And the key to knowing when conversations outside of public meetings might be violating RSA 91A is the content of what is being discussed. because if it's related to matters which that public body has control over, it's official business of the public body, then it needs to be discussed. It needs to take place in a public meeting. But if it's not, if it's a social discussion, or it is not related to the official business of the public body, then at that point you may not be running into a potential violation of RSA 91A.
Question.
Yep.
So if someone sends, so if the chair sends a message to the whole board of like information that's pertinent, they can send it out, but you cannot respond all.
Right. The key to that, there's nothing wrong with sending out information ahead of time to make sure that your board members have documents or have information that's going to be pertinent to the discussions during the public meeting. The key is making sure that nobody hits reply all, and now they're talking to a quorum or a majority or all of the public body, and they're not responding with discussion, right? They're not responding with an opinion or a new fact that's related to the information that was sent to them. The easiest way you can avoid doing that is by using the BCC function on email, so that if anyone ever does hit reply all, it's only going to go back to the one original sender. In an even more ideal scenario, that original sender is not a member of the public body, but an administrative assistant. So that way you don't have two members of the public body communicating back and forth. There you don't have a quorum, so you're not strictly risking the RSA 91A provisions, but you could be sort of violating what the statute calls the spirit of RSA 91A, which I'll talk about a little bit in a minute, but it's one of the reasons why I said at the beginning, if you don't have all four of these elements present, then you shouldn't be doing something that should otherwise be done in a public meeting. And what I mean by that is I always get the question, well, there's 5 of us on our public body, so if I show up, so that means 2 of us can talk about anything we want outside of a public meeting, as long as we don't have a third show up. Then we're not violating RSA 91A. And I would say to that, well, yeah, technically you don't have a quorum, so you don't need to post a public meeting and have the public present and take minutes. But there is a section in RSA 91A, it's RSA 91A:2, which says that nothing in this chapter should be construed to violate the spirit of the law. And what we lawyers say the spirit of the law is pulled from the New Hampshire Constitution, which is where RSA 91A was sort of born out of. And the spirit or the point of RSA 91A is that members of the public should have the utmost access to what its government is up to and what the discussions that are taking place that are influencing the decisions that your elected or appointed officials are making. So if you have 2 members of a 5-person public body that are constantly talking and discussing and coming to agreements behind closed doors, even though that's not a quorum, that's really violating the spirit of RSA 91A. And there could be other problems that sort of snowball from that. So it's why we recommend, if you have an administrative person that can handle sending out your mass emails, that's the best scenario. If you don't, then not only should you use the BCC function, but you should also make it clear that any responses should be simply, a yes or no response. Are you able to make it to the meeting tonight? Yes, I am. Here's a bunch of materials that are relevant to the discussions that we're going to have. Response, okay, thank you, I got it. See you at the meeting. That's what you want to keep your discussions to, not anything that could otherwise be viewed as substantive. Yep.
So if we had an online platform where we could pick up the documents that would, instead of them being sent through an email,
Yep.
they're put there and we can pick them up.
Yeah, like a portal to pull them from.
So how does that intersect with 91A?
So a great question, and I'll get to some of this stuff now because it's good. It's coming up. I have an example coming up of there's nothing. That's actually a great tool to use, like an online access portal where you can pull documents from. And there wouldn't be any issue with violating RSA 91A with that, unless sometimes some of these platforms, especially anything that operates with a cloud-based sort of real-time updates, there could be a risk of unintentionally engaging in contemporaneous communication if you have the ability to do something like make comments that can be seen in real time. So one of the things that we see with this, and it may not be exactly what you're talking about, but if you have the ability to edit a document, like let's say you have a draft of your rules of procedure that one person has created and it needs to be discussed at the next public meeting where it's going to be voted on and adopted as amended rules of procedure. If that, let's say it's a Word document, is available through the Microsoft Cloud, cloud-based software, if I go into it and I start making edits or comments to it, everyone else who has access to that document can see in real time the comments that I'm making. And then they could respond to the comment that I just made. And then I could see that. And then I could respond to the comment that they made on my comment. And as you can see, now we're having a back and forth contemporaneous discussion about edited rules of procedure that need to be discussed and adopted in a public meeting. So those are some of the things you just want to watch out for when it comes to online portals or software.
So don't use that for it.
Yeah.
I was gonna say, so then just to make sure that I understand correctly, the proper answer then would be if somebody has a draft that they send out for review at the next public meeting and voting and all that, they send it out and everyone looks at it on their own time, makes notes for themselves privately that they want to bring to the meeting, and then it gets discussed in that public forum, but there should be
Right.
absolutely no back and forth in the
That
email.
would be the way that you would handle it. Other than, hey, you missed a period at the end of the sentence, right? Like something like that, or, that would be different. But any type of substantive discussion about something that the public body has control over, you'd want to hold off on. Yep.
So if you could go back to the whole quorum thing and quote-unquote meetings behind closed doors for just a moment, because
I would draw the line. So we get this question every time NHMA holds a training. We get a call from a 3-person select board that says 2 out of the 3 select board members want to drive to your training and they'd like to carpool. Is that illegal? And we say, no, it's not. There's nothing wrong with 2 out of 3 members of the select board driving in the same car together. Don't talk about select board business. Talk about your kids. Talk about, your weekend. Talk about your vacations. Don't talk select board business. That needs to be kept in a public meeting. And again, if you have less than a quorum, so 2 out of the 5 members of your board, you invite 1 person over, you have less than a quorum, there's no 91A police that are going to show up and see what you're talking about. But think about it like this, and this is where the sort of spirit of the ordinance issue comes in all the time, is we get these questions with usually during this time when we have newly elected board members. I just got elected to this particular public board or body, and I noticed that every time I show up to these meetings, 2 out of the 5 members of this body seem to be on the same page about everything. And we haven't discussed any of these issues in public, but they're always voting the same way together. They always know what the other one is going to bring up. It's like they planned this whole thing out ahead of time. And me and the other, 1 or 2 new members elected feel like we're sort of fighting against them with everything, and we don't even know why. And the reason for that, 99% of the time, is because those two people who've been on the board forever are meeting out together outside of public meetings, and intentionally or not, they're influencing each other's decisions, they're changing each other's minds, they're creating this sort of mini committee within the public body. And that really does, in my opinion, violate the spirit of RSA 91A. And sometimes it's not even intentional; it just happens. And it's why, that's why we say to sort of be cognizant of those type of discussions that might happen outside of a public meeting. So that would just segue into. Oh, you have a question? Yep.
I just have a quick one. You said it had to be, the public meeting had to be published, and you said one of the places is the website, the town website.
Yep.
What would be the other place?
The other place is the place of the meeting, but I'm gonna get into notice requirements once we get to that point. We'll talk about that a lot more. So we've already discussed this a little bit. The last piece, obviously, is that what is being discussed needs to be the official business for it to be an issue, and so that's why there's absolutely no problem with having a holiday party where all 5 members of the board are present, or a barbecue where the members of the board have become friends. They can all be together. The entire public body can be together for social encounters, and there's no issue with that as long as they're not discussing the official business of the public body. So those are all the elements that we talked about that are instances that would constitute a meeting and therefore require notice and minutes and open to the public, which we're going to get to. But there are some things that are considered not meetings. And if something is not a meeting, a non-meeting or not a meeting, not only does that mean that the rules of RSA 91A don't necessarily apply, it means that you don't have to post this. It doesn't have to be open to the public. There doesn't have to be minutes. It doesn't live under RSA 91A. And those are social encounters, as I just mentioned, collective bargaining negotiation discussions. So that's a carve out in the law where the law has specifically said, we understand that you would lose, all of your negotiating power if everyone was able to know, what your bottom line was in negotiating or negotiating a collective bargaining agreement. So those discussions are not meetings. You don't have to post them. You don't have to take minutes. They're off the books. Consultation with legal counsel. So this applies when your attorney is actually present or on the phone. When you have real-time communication with your attorney, that is not a meeting. It doesn't have to be noticed, minutes taken, or open to the public. Circulation of draft documents. So again, when you send that draft of the revised rules of procedure or whatever it is, your planning board is changing their subdivision regulations, and they have a draft ready and it needs to be reviewed. You can circulate that draft around to all the members of the public body for review, and that's not a meeting. There's no issue with that. You just need to make sure that if there's discussions about the circulation of the draft document, that the discussions take place during a properly noticed public meeting. And then finally, this is different than non-public sessions, which we'll talk about in a minute, but non-public sessions are parts of a public meeting. They just take place within a public meeting. So what are the requirements of a public meeting? There are 3 requirements that you're always going to have to meet. You're going to have to post public notice. You're going to have it open to the public in a public location, and you're going to have meeting minutes. So what does notice look like? Well, RSA 91A is what we call the bare minimum amount of notice that you need to post for a meeting. And what it says in RSA 91A is that you have to post 24 hours in advance in 2 public places. One of those public places can be your website. The other, ideally, is the place where the meeting's being held. You could also post it at town hall or some other available public location. There are, however, many, many different areas within the statutes that require much more than just 24 hours public notice. Sometimes you have to notice specific individuals, like with a ZBA hearing, for example. You have to send out notice to the specific abutters. Certain acts take 7 days of notice or 10 days of notice. When you're prepping for your town meeting, there are things, the budget hearing takes enhanced notice requirements. So you always want to make sure that whenever you're doing something other than just a regular public meeting, if you're going to be adopting an ordinance or you're going to be, voting on a variance request or something like that, you need to make sure that you're checking the statutes to make sure that you've posted enough notice, because it's very likely it'll be more than just the 24 hours. When we talk about switching back to in-person meetings, so the meeting has to take place at a public location. As I said at the beginning, emergency order number 12 used to allow for meetings to be held remotely over Zoom or something like that, but that's ended now all the way back in 2021. So at this point, there must be a physical location for all meetings. In fact, even if you have to hold an emergency meeting, which is one of the only times now that you can have less than a quorum present physically in person, you still have to designate an in-person location for the public to meet at. And in most instances outside of an emergency, a quorum of the public body has to be physically present at that location. If you have a quorum present, then you have the option to allow for the remainder of the members to attend virtually if your board chooses to allow that. There are a few things you want to take into consideration. Nothing prohibits boards from offering electronic access like Zoom or telephone to the public. You can continue to offer the public the ability to live attend a conference or a meeting. But you should definitely have participation rules if you're going to allow that. I would recommend not allowing people to speak or comment on Zoom. That can get complicated. You don't have to restrict that, but it is something to consider. And you want to decide whether or not you're going to allow anonymous participation, or if somebody has to have a name associated with their account. And you definitely want to make sure that you have turned off screen sharing ability. I got a question the other day about whether or not they needed to keep in their recording when a participant hijacked the screen sharing and showed a video that nobody wanted to see during a public meeting. And they wondered if they could cut that portion from their recording. And the answer was yes. And the other response was, make sure you don't give people access to screen share on Zoom if you're using that as part of your public meeting. So you want to have some rules in place related to that. Yep.
So if you were using a Zoom, you have the quorum meeting in an actual location, but you've invited the public to be part of a Zoom, and maybe some of your members are there too. And you're looking at the slides like we're looking at tonight, but we can't discuss your slides on the Zoom.
No, I'm not saying I'm not saying the board can't discuss the
board
slides.
Can't, but the public can, I assume.
The public could if you give them that option. So when it comes to public meetings, the public doesn't have a statutory right to speak during a public meeting. They have a statutory right to speak during a public hearing. But for your run-of-the-mill public meetings, the right to speak or have comment is something that you as a board or a public body choose to allow. And when you choose to allow public comment during public meetings, you are also allowed to implement reasonable rules that don't violate the First Amendment, which would be reasonable time, place, and manner restrictions. So you can have rules in place as to how long people are allowed to speak, or what the process is to be recognized to be allowed to speak. And one of the options that you could choose would be to limit participation from people who choose to show up remotely. I think that's a reasonable restriction, although it's not something that you absolutely have to do. It's just a consideration. And one of the reasons for that is because it can be difficult to know who it is that is speaking, whether this person is, or who they say they are. It can make things somewhat complicated, more complicated than allowing people to speak who physically show up in person. So it's just a consideration. And this is for members of the public. It's different when we're talking about members of the public body, because when it comes to remote participation of members of the public body, we have a specific statute on that, and it's RSA 91-A:2. And what the statute says is that public bodies may allow an individual to participate remotely if it is not reasonably practical for them to appear in person. There still has to be a quorum present, physically present at the location. And if you're going to choose to allow someone, a member of the board, to participate remotely, they get to participate as if they were there in person, meaning they get to vote, they get to discuss, they need to be able to see and hear just as if they were there in person. They need to be able to be brought into non-public session if you're going to enter non-public session. They are treated exactly as if they were there in person if you choose to allow this practice. There are a few things that you have to do in order to make this happen. So first is that the statute says in order to allow someone to participate remotely, it has to be stated for the record, for the minutes, why it was not reasonably practical for them to be there in person. Now that term isn't defined in the statute, so it's up for interpretation, and it's up for each individual board and body or municipality to set some of those rules as it works for their particular community, so or their particular board or body. And you can define that for yourselves in your rules of procedure. As a public body, you have the right to adopt your own rules of procedure, how you want to handle your public meetings. And within those rules, you could choose to lay out some parameters as to what not reasonably practical might mean. So that member who is on a business trip every single week and can't make a single meeting, is that going to be viewed as not reasonably practical for your particular board or body? It doesn't have to be. You can decide sort of where you want to draw that line. There are some obvious scenarios where A reasonable person would absolutely find it not reasonably practical, like I'm in the hospital, but I still want to participate because I physically can. That would be a good example. Whatever it is, they have to state it for the record, and it has to be recorded in the minutes. It's also necessary to identify for the public or a board member who's appearing remotely. Once you allow remote participation, then all votes have to be done by roll call vote. And I would also just add that if you're going to allow somebody to participate remotely, a board member, you want to consider asking them if they are alone or if anyone else is available or is present with them who can hear and see what they're doing. That would be relevant information, especially if you're going to enter into non-public session or something like that. And just to finish off, the reason why we highlight that the statute says that a public body may allow remote participation is just to let you know that it's your choice and you don't have to. And there could be a scenario where your particular board or body may want to choose to not allow remote participation, at least for a period of time. And the reason why I say that is because, unfortunately, we do get these scenarios where, I get this question. We're a 3-member public body. Someone was elected to our public body, but they spend 8 months out of the year in Florida. And so they want to, for all of those 8 months, they want to be allowed to participate remotely. And if we allow them to do that, then no one else can ever participate remotely during that time that they are, in an extended period out of state. One of the solutions to that scenario may be to not allow remote participation if you find yourself in a situation like that. But just know it's your choice as a public body. And if you're going to choose to allow it, you want to make sure that you follow the proper procedures that the statute lays out. So I mentioned an emergency. An emergency is really the only remaining scenario within the statutes that would allow for less than a quorum to be physically present. In order for this to happen, the chair of the board must declare that an emergency exists sufficient to satisfy the requirements. The requirements are essentially that there is an emergency situation, action is needed, and any delay to that action would cause substantial harm, either to someone physically or financial harm, but there has to be an emergent or an immediate need for action to justify calling an emergency meeting. As I mentioned, it still requires a physical location. However, a quorum doesn't have to be present at that physical location. You can have less than a quorum. You still need to make sure that everybody who's appearing remotely can see and be heard adequately, and you have to identify anyone who's appearing in a remote location. And once again, all votes need to be done by roll call. So in our question in the back?
Yes, so I've heard you say a couple of times, see and be heard. So does that mean that you discourage people dialing into meetings on a cell phone?
No, that would be permissible. Most of the time nowadays it's done by Zoom, so that's why I talk about being seen if they wish to be seen. But realistically, the key is that they can participate as if they were there in person. So that just means being able to hear everybody who is speaking, and everybody can hear them when they speak, which may require, sometimes you might have to repeat questions in the audience if that was if someone's speaking out in the audience and the person on the phone can't hear. You just need to make sure to accommodate those needs. Through all of our interactions with municipalities and the stories that we've heard, we put together just some useful tips for dealing with electronic communications to make sure that you're complying with RSA 91A. I've talked about several of these already, but consider using an administrative person. Make sure that you do use the BCC line on an email. If you're going to send an email out to the entirety of a public body. Sending email to a quorum of a public body could be deemed a violation of RSA 91A, where that person could hit reply all and then start an improper electronic communication. Use of a city or town email address. This is another important one. You'll understand this more when we talk about governmental records. But when you're communicating with other members of the public body or with your administrative officials or whoever it might be about your official business, about public body business, and you're doing that via email, you are creating governmental records. And those records have rules and laws that apply to them. Some of those records need to be kept and retained. Some of them, in fact, all of them, could be subject to disclosure if a member of the public asks to see them under RSA 91A. And so it is never recommended to commingle your official communications as a local official with your personal communications on your personal email account. What that does is opens you up to losing communications that might be considered governmental records. And if somebody makes a right to know request and you don't provide those records because they're on your personal email account and you either deleted them or you forgot that they were there, you could find yourself in a situation where, at the very least, a judge is looking through your entire Gmail inbox and everything that's in there, looking for governmental records. And not many people would want to be in that scenario where they have to turn over access to their personal email account. So there's two ways that you can avoid running into that scenario. The first is to use an official city or town email address if one is available to you to use. That's the best option because that would be protected by whatever your IT department protections are. It would be accessible by those who need to access it for governmental record purposes. But the other thing that you can do if you are maybe appointed to a smaller subcommittee or something like that and you don't have the ability to get an official email address is just to make a dedicated email address yourself. You can do it for free on Gmail. You can go create a John Smith subcommittee at gmail.com email address and use that for your communications, and don't use that for personal communication. At least that way you have all of your official communications in one spot, and you're not going to have to worry if somebody says, I'm making a right to know request for any email communications regarding the planning board's updating of their subdivision regulations. If I communicated about that via email in my separate planning board email account, then I know that's the only place that I have to look. It just makes life a lot easier.
I think I just add to that. We had a situation recently where we had a right to know request and they wanted all communication. So we've got people sending text messages that are government business on their personal phones. They're using their personal email addresses. They're using their apps and social media where they're communicating with other people. And the problem we have with that is when we sent out the request, they provide all that to us, either we got no responses from those officials, or they said they didn't create any in their personal email addresses. Remember, whatever you send out, it exists out there. Everybody else who you sent it to has it. It's out there. And unfortunately, what we found out was they told us they had no such records, but the people that they sent it to, they still have it. Real serious problem for us because there are criminal penalties for that. And there are significant fines for that for the municipality as well as the government official. So I would urge extreme caution because we've had that happen here in the short period of time that I've been here. We can't afford to have that happen. It not only does it violate the law, it totally shatters the credibility of our governmental operation, that we're operating in the sunshine and we're being transparent and doing the things that we're supposed to do. So if anything else, I would ask that you would seriously consider not doing that, not to mention it's a violation of the law.
Exactly. And what that looks like, right, in practice is that person that you all probably know in town, hope maybe you don't have one, most towns do, that's always filing right to know requests, right? They file a right to know request and they ask for all email communication about something. And what they get, they're not satisfied with, and they know that there's something out there, and so they file a lawsuit. And then there's the lawsuit starts and people have to come in and they have to give testimony about where they communicated about this particular issue. And it turns out, well, yeah, I did use my WhatsApp account to text so-and-so, or I did use my personal email address. And then a judge gets a subpoena and then a copy of your phone's text messages are sent to the judge, and the judge is now reviewing all of your text messages to see if there's governmental records. I mean, that's how it could play out, and that's from a personal standpoint, you don't want to be in that position. You want to be able to say that everything that you have related to the request has been provided, and that there's no reason to dig into your personal accounts. Yep.
So if when talking about a document, if I'm creating a document to be used in that public body, the document that I'm creating, that's accessible by 91A, I assume, when I submit it in the public meeting. But, so if I'm doing it on my own computer, what's the risk to that? Now is my computer
No, so
searchable?
right, the document that you're creating, if you're using your personal computer, it doesn't become a public record until it's been accepted by the public body. And then you've got the document, you've got the governmental record. That's what's subject to disclosure under RSA 91A. So it's the bigger concern is those like day-to-day communications that happen rather than sort of like an official draft of a document. So meetings open to the public, as the statute says, all meetings have to be open to the public. Each part of the meeting should be open and audible, otherwise discernible to the public, other than the non-public portion, if you have one during that meeting. The public has an absolute right to record during public meetings. They don't have to ask permission. They don't have to tell you that they're recording. Any member of the public can show up to a public meeting and record that public meeting in whichever way they want, audio or video. The only thing that you could do is you could make sure that they're not doing their recording in a way that's disrupting the meeting. You could ask them, they don't have the right to put a camera right up in your face and block your ability to see the meeting. You could ask them to record from a specific area, but you can't limit the public's ability to record public meetings. You can also never engage in secret ballot voting. That's only reserved for town meeting. So I got this question just the other day. Can our planning board write their votes on a piece of paper and hand it to the land use official, who then counts the votes and says whether or not it passes or not? You cannot do that. The public has a right to know who voted which way for their elected or appointed officials. So no secret ballot voting for any public bodies other than during your town meeting. And then public comment, I already mentioned that, but if you're going to, you can choose to allow public comment if you want, and if you do, you want to consider putting in some rules of procedure for how that's going to happen. Some of the comments that we have on public comment, some of the observations we have, again, the public body should have rules to govern how people are allowed to speak. Those rules should be made clear to everybody so that they know what they are. When you choose to allow public comment, you've created a public forum, which means you've triggered the First Amendment. So now you have to make sure that you are not violating the First Amendment, which means that you have a very, very limited ability to restrict the content of what people say in your public meetings. If you allow them to speak, you pretty much have to take the words that come out of their mouth as they are. There's very little room to hinder what someone's going to say. You can't restrict them from using profanity. You can't restrict them from using vulgarity or offensive speech. All of that is protected speech under the First Amendment. For now, at least, it's still there are instances where we've seen some newer interpretations of that, but for the most part, our legal understanding is that those type of comments are still protected. A question in the back?
Sure, thank you. So, can we restrict bullying behavior? Can we restrict threatening behavior?
Well, threatening is a legal word, right? So there's a crime called criminal threatening, right. And there are criminal grounds where speech could cross a line into a crime, or conduct could cross a line into potentially disorderly conduct. It gets complicated when you get into that. But for the most part, you really can't restrict the use of profanity, vulgarity, or...
No, I understand that, but if we have an individual who's speaking in public comment who becomes verbally abusive and begins threatening assaults on boards or board members specifically, is that something that we can address or not? Right,
so again, there's a different... So verbally abusive is not... that's up for interpretation. Threats or threatening assault that's a different story. So this is my point. It becomes complicated. So you want to make sure, if you feel that certain comments are beginning to cross that line towards a potential crime or a threat, then you could get the police department involved and you could address it that way. The easier choice that you have, or the better option, is to try to put in what we call reasonable time, place, and manner restrictions to the speech that you allow, which is, if you want to speak, you have to sign up ahead of time. If you're going to speak, you get 5 minutes to speak. It doesn't matter who you are or what the topic is. You get 5 minutes. Everybody gets 5 minutes. we're going to limit public comment to the first 10 minutes of the first 20 minutes or whatever of the meeting. So only the first 4 people that sign up will get to speak that meeting. And if you weren't one of the first 4 people, first come, first serve, then wait till next meeting and sign up. Things like that can sort of help curtail some of those issues. Worst comes to worse, if you do have a problem and it's not being resolved by your time, place, and manner restrictions, another option is to suspend public comment. Like I said, it's a right that you're giving people to speak. They don't have it inherently at a regular meeting. So you could choose to, for a time, suspend public comment. Question?
What if somebody's speaking to a committee and says, I am not leaving the podium until I get an answer from this committee?
So that is not, right, that's not permitted necessarily, because it's not, the public comment is not a right to get an answer. It's a right for you to speak for yourself. You can provide your comment.
So the committee doesn't need to respond.
The committee does not need to respond. You don't have to be compelled to respond. And the way that you address the person who says, I'm not leaving this podium until I get an answer, is to remind them, hopefully, of your rules of procedure that say you have 3 minutes or whatever it is. And if they refuse to comply with that, now they're not complying with the rules of procedure. You're drifting away from a First Amendment issue and more towards a potential reason to have them removed. It's a bigger discussion than we really have time to get into today, because I could talk for probably 2 hours just about public comment and the First Amendment. But the biggest takeaway that I want you to have from this is that, I'll probably say this 3 more times, you can draft rules of procedure as a public body. So for those of you who are members of public bodies, consider drafting rules of procedure if you don't already have them, especially if you allow public comment, because it's one of your best tools to keep the board on track and to keep the public on track. Meeting minutes. So at a public meeting, you have to take meeting minutes. Meeting minutes are not very clearly described in the statute. In fact, this is really the statute. This is what it says as to what needs to go into meeting minutes. The names of the members present, the person appearing before the public body, a brief description of the subject matter discussed, state final decisions that are made, and state the names of the members who make or second each motion. That's all that the statute says, at least in that portion, as to what must go into your meeting minutes. There are a few other areas where the statute does specifically say this information must go in the meeting minutes. We already talked about one of them, why it's not reasonably practical for somebody to appear in person. That has to go in your meeting minutes. And when you enter non-public session, which is the next couple slides, you have to include in your meeting minutes why you're entering into non-public session. For the most part, everything else is up to the board as to how much detail you want in your meeting minutes. My practice tip would be, for the run-of-the-mill public meeting where you discuss a few pieces of business, you maybe allow public comment. You don't need to get too deep into the weeds in that. And the public doesn't get to dictate what goes into your public minutes. So when somebody stands up and rants for 10 minutes about a topic that you don't particularly want to take down word for word, you don't have to, even if they want you to. You can put, John Smith spoke for 10 minutes. He's unhappy. That's a fine meeting minute for what, John just talked about, if it comes down to that. For more official type of decisions, like, for example, if you're on a land use board and you're doing you have a public hearing about granting a variance, take very, very detailed meeting minutes. You need those meeting minutes to create your notice of decision, which is going to be the foundation for an appeal, if there is one, on your action. So when you're discussing things like implementing a weight limit on a town road as the select board, and you have testimony about the condition of the road and maybe some more technical details that are discussed about the road, that's the stuff you want to take in more detail in your meeting minutes so you can go back and look at those. Yep.
Sorry, I can wait until.
Oh, go ahead.
I wanted to just confirm that I understood correctly that a subcommittee also needs to create meetings for their meeting.
Yes.
And
Yep.
we decided on.
All committees, all subcommittees need to take minutes of their meetings.
Thank you.
Minutes must be available within. Yeah. Go ahead.
This meeting's being recorded, many of our meetings are recorded.
Mm-hmm.
Where do you draw the line in terms of detail between a brief overview, minutes report, and public record that's recorded on a
Do you mean like using the recording in place of minutes, or is that what you're asking?
in terms of the depth of the discussion. We can put together abbreviated minutes, but does the recording itself represent a public record to back that up?
So a recording of a public meeting is not meeting minutes if you choose to make separate minutes. So the important piece of that is, so if you're recording your public meeting, you have the recording. That's a governmental record, but there's no retention period, specific retention period for how long you have to keep that recording, as long as you've created minutes for that meeting. If you're choosing to use the recording as your minutes, and that's it, that's the only memoranda of what happened. Now that recording becomes the meeting minutes. Meeting minutes have to be kept forever. So we recommend creating actual minutes instead of using recordings. One, because that storage space can add up quickly when you have recordings that have to be kept literally forever in the statute. If that's what you're using for your meeting minutes, you're going to have to figure out a way to keep those recordings and make them available to anybody who requests them forever. It's a lot easier to have a 1 or 2 page piece of paper or PDF or whatever it is of written minutes that you can provide. If you're doing that, then you can keep those recordings as long as they're useful to you, and then you can destroy them when you don't need them anymore. So it's a choice that you have. Yep.
You won't be able to keep electronic stuff forever. When was the last time you saw a floppy disk?
Right. So I think the point is, right, you have to find a way to store that recording for as long as you can, and when a new form. So if you had governmental records on a floppy disk, you'd be expected, if they had to be kept forever, to find a way to transfer that into a new electronic medium that could be kept.
That's my point. You can't rely on it forever. You're going to have
Right. I think paper meeting minutes are
Paper's the
now
only way.
a PDF meeting minutes probably is the best way to handle it. The statute says that minutes need to be available within 5 business days, but that doesn't mean you have to have your final approved meeting minutes. All that has to be made available is draft meeting minutes. If your draft minutes aren't available within 5 business days and somebody makes a request for those minutes, then what you would have to provide them is any notes or raw materials that are going to be used to create the draft minutes. But something has to be available within 5 business days. Yep.
Okay, how about AI now? What's the deal with the AI stuff? So if can AI be used to generate minutes from a transcript of a recording?
It could.
As long as it provides the required things of the people's names and et cetera.
Right. I'm not going to give a specific opinion on whether you should or shouldn't use AI. I think I'd leave that to your municipality's own policies. But what I would say is, if you're going to use AI to review a transcript and produce minutes, have a human review that to make sure that they're accurate. I think that would be the best way to handle that.
Thank you.
As far as posting requirements, the law only requires that approved minutes be posted. And many people are surprised to find out that the law doesn't even require you to approve your meeting minutes. That's a choice. Many boards do it. There's nothing wrong with doing it. But there's no sentence in RSA 91A that says you have to approve your meeting minutes. You just have to create them. So if you don't approve them, if all you have are your draft meeting minutes, then they just need to be made available upon request. If you do approve them, then the law says that approved minutes must be posted on your website if you have one. So the use of software, there's dictation software now, there's AI. People are trying to use those to create meeting minutes. It's a great tool, I think, as an aid for creating meeting minutes, but you do want to have somebody who's familiar with what was discussed review it, just to make sure all the important information is getting there.
Approved minutes on the posting replace draft minutes, or should
Yes.
both be? Oh.
They do. Once the minutes have been approved, they can replace the draft minutes. So, non-public sessions under RSA 91A3, the law gives public bodies the option. Again, it's an option. It's a may to enter non-public session. It's a non-public session. It's not a non-public meeting. So it's a small session that takes place within a larger public meeting. It's different than a non-meeting. You still need to have minutes taken. You still need to follow the proper rules of RSA 91A. It's the exception, not the rule. So what I mean by that is that you can't be forced to go into non-public session. Sometimes it's the right idea to do that. It's the right call to use non-public session to protect certain information. But even if something qualifies to be discussed in non-public session, you don't have to enter non-public. You can choose to have that take place during public session. They are permitted, they're not strictly required. In order to enter non-public session, you have to meet one of the criteria listed in the statute, RSA 91A:3, paragraph 2. I think there's something like 13 different reasons why you can enter non-public session. They're listed in the statute, but the most common ones are to discuss a specific public employee, not a department, not a group of employees, but one specific employee. Hiring an individual, discussions that would constitute harm to somebody's reputation, purchasing property, lawsuits, emergency preparation, discussing legal advice, different than talking with your attorney. If you're talking with your attorney, it's a non-meeting. If you're discussing the advice that you previously got from your attorney and your attorney's not present, that's non-public session. And discussing student tuition contracts. There's a specific process that you need to follow in order to enter non-public session. First, a motion needs to be made. Usually that's done by a board member. I suppose a member of the public could motion the board to enter non-public. But nonetheless, a motion needs to be made. And when it's made, it has to state in the motion which portion of RSA 91A:3 justifies entering non-public session. So it would sound something like this. I motion to enter enter non-public under RSA 91A:3, paragraph 2, section C, which is the reputation one. I motion to enter non-public session under that portion of the statute to discuss a topic that I think would potentially harm this person's reputation. That's what the motion should look like. The vote should be done by roll call, and a simple majority agreement is sufficient to enter non-public session. So I'm running a little short on time for this portion, so I'm going to go through these a little quickly. But essentially, for this one, dismissal, promotion, or compensation, disciplining, or investigation charges against a public employee. Again, this has to concern a specific employee, and you want to make sure that this employee does not have a right to a public hearing. In certain employment contracts, there is a right for them to have a public hearing before any disciplinary action is taken against them. So if you're choosing to enter non-public session to discuss this, and they have a right for it to be done in public, you want to make sure that they're made aware of that right if they want to invoke it. Matters which would likely adversely affect the reputation. This is probably the most used reason to enter non-public session, and it also, I think, is the most abused portion. Boards that like to go into non-public session a lot tend to use this to do it, but the statute really wants there to be some actual tangible harm that's going to happen to this person if the matter is discussed in non-public session. It shouldn't, for example, be used to allow members of the public to simply complain about other members, their neighbors, or members of other public bodies, or the town administrator or town manager, or whatever. A lot of times boards use that to enter non-public session. I don't think that's what it was really designed for. It needs to be some type of communication which would harm a person financially, or maybe an allegation of a serious crime against them that's not founded at this point. That was the real point of the reputation prong for this section of non-public sessions. Minutes have to be kept during non-public session. You have to record all actions and votes that are taken. You are allowed to vote in non-public session. It's conducted just like a regular public session. The only difference is that you kick everybody out who doesn't absolutely need to be there. When you're conducting the session, you can, like I said, you can make decisions. There's an interesting provision in the law that says that if you feel the board has not properly entered non-public session, maybe they're using the reputation prong and you don't think that this matter really met the criteria, You can object for the record to the use of non-public session and say, I think we should have stayed in public session. And your objection is recorded in the minutes, and then you're free to continue discussions. You're sort of protected to continue participating. And finally, the cleanest way to do it is to end non-public session and return back into public session before ending the meeting as a whole. Some other considerations are including on your agenda. If you know you're going to enter non-public session, you should have that included on your agenda, and be conscious of the timing. Do you want it at the beginning before you invite everyone else to come back in? Do you want it at the end? Think of when you want to hold it for convenience. And non-members, meaning individuals who are not members of the public body, are allowed to attend non-public sessions, but they should only be there if their attendance is necessary or relevant to what's being discussed. Yep.
I have a question based on, so with the whole, somebody's appearing remotely, say by phone, so not visibly, a member of the public body's on the phone, and we have no way of knowing if somebody is in the room with them or not in the room with them from where they're appearing, and the body goes into non-public session. Is there a consequence for that? How does that play out?
Right. I mean, there could be a consequence. You should, they should be asked whether or not they're alone, so that they provide an answer. And then if they've been untruthful, that could be viewed as potentially a violation of their oath of office. I think if they there's also a provision in the statute which requires members of public bodies to keep confidential information confidential. So if they were allowing the information, which is confidential at the time it's being discussed in non-public, to be disseminated to somebody else who was in the room, they could be violating that provision of the statute, which could be potentially even grounds for being removed from their position in the worst case scenarios. So minutes of non-public sessions, they are not sealed by default. Once you end non-public session, you have 72 hours to vote to seal those minutes. And the vote must be determined by a 2/3 majority vote taken in public session. And the only time you should be sealing your non-public meeting minutes is if, under the statute, it says disclosure would adversely affect someone's reputation, it would render the proposed action ineffective, or the discussion pertained to terrorism. If the discussion didn't meet one of those three criteria, then your minutes shouldn't be sealed. Your minutes are also not sealed forever. They're only sealed for as long as necessary to protect one of those three issues. And you need to be unsealing your non-public meeting minutes as they no longer need to be kept secret. And there was a relatively new law on this. Back in January of 2022, the law changed, which now requires all public bodies to keep a running list of their non-public meeting minutes that have been sealed. It has to identify which public body, the date and time of the non-public session, why they entered non-public session, the date of the decision to seal the minutes, and the date of the decision to unseal the minutes. So that's a list, and that list itself is a public record that all public bodies are supposed to be keeping if you're entering non-public session. You also now, starting October 2023, have an obligation to review all of your sealed meeting minutes. The revision to this law essentially said that over the next 10 years, public bodies are supposed to be reviewing all of their sealed meeting minutes and determining whether or not they should be released. There was not a lot of guidance given by the legislature when they created this statutory amendment. We don't know what the consequences would be if you don't adhere to this regulation, other than that any minutes that were not reviewed are going to be automatically unsealed. So I don't know what's going to happen, in October of 2033. But what I can advise is that you should at least be attempting to review your non-public minutes and decide whether or not they need to remain sealed or if you can release them. Yep.
Did you have to have a non-public session to review them?
No. The way that I think the most effective way of doing this is to assign one member of the public body to sit down and review the minutes and make a judgment call as to whether or not which ones maybe should be unsealed. And then you can take that stack of the ones that might need to be unsealed and vote whether or not you should unseal them. And the vote can be in non-public session, or the discussion. That's one of the prongs in 91A:3. It says discussions on whether to unseal meeting minutes can be done in non-public if you think that there might still be sensitive information there. So some tips for effective meetings. I'm going to go through these last few pretty quickly to get to records. But it's nothing that you all, I'm sure, don't already know. It's just helpful to be reminded. Being prepared is obviously something you want to do. You want to review any materials ahead of time. See if you have rules of procedure in place. Using an agenda is not legally required, but it's a great tool to keep you on track. Circulating materials in advance, reading and thinking about your comments, avoiding discussions outside of meeting minutes. If you're going to, if you have or you want to amend rules of procedure, some great things to think about are including a regular meeting day, time, and location. If you meet every week, keeping it consistent can help with things like notice. Election of officers. Most public boards and bodies don't have a statute that says how or when you elect a chair or a vice chair or something like that. You can choose that for yourselves in your rules of procedure. What the authority of your chair or vice chair is going to be. How much control do you want to give to that individual over the day-to-day operations of the board? Some quorum and voting. Like I said, you can't have secret ballot voting, but you can use other forms of voting. You can do roll call. You can do voice vote. You can do standing vote, things like that. How topics are going to be added to an agenda, whether that's going to be a decision of the chair or of an administrative official. You can include that in your rules of procedure. What your order of business is going to look like. You can have rules for decorum. Those are not strictly enforceable in many instances, but you can still have a policy for how members of the public body should act. You can also adopt an ordinance for they call them conflict of interest ordinances, but you could have a local ordinance, or you could have rules of procedure on decorum. Comment we already talked a lot about. You want to be clear that you follow the right to know law, that all discussions are going to be had in public, minutes are going to be taken. You want to be clear, especially with your subcommittees, what it means to be a liaison. So I get this question all the time, is that we get a subcommittee and they say, well, my subcommittee has a select board liaison. Are they a member of the committee? And I have to say, I don't know. I didn't create the committee. You did. So you got to tell me, is the select board liaison an appointed member of that committee? Or did you sort of create an ex officio member of the select board that's a voting member of the committee? Or are they just there to observe and then they're going to report back to the select board? That is up to you when you create those committees to define, whether the main public body, the select board or planning board or whoever it is, if that liaison is going to be a full voting member or really just there as sort of a more or less a member of the public. And rules on enacting ordinances or resolutions and motions, how your board is going to handle that. All of those are just some of the considerations you might want to have in your rules of procedure. So we're going to move on to governmental records, but before I do, are there any other questions on the stuff we just talked about? Yep.
Just a question about subcommittees. Are subcommittees permitted to have a non-public session within there?
Mm-hmm. Yes. Yep.
I have two questions. So one of your slides talked about emergency meetings. Emergency was in quotations. Is there a definition of emergency?
There is, and it's in the statute, and I don't remember word for word, but it essentially...
Thank you. If it's in the statute, I'll find it.
Yep.
So,
it's defined in the statute as a scenario that needs immediate action or else harm will occur.
Thank you. Second question, you had mentioned, you made a statement that you cannot control in public comment what people talk about, but is that different for like the ZBA or planning board, where you have a specific cases and/or properties that are noticed?
Yes. So it is different, and that's because I don't think I gave this distinction enough. There's a difference between a public meeting and a public hearing. And so a public meeting is, again, your run-of-the-mill meeting under RSA 91A. When your select board meets, that they're usually having just a public meeting. That is the public meetings have nowhere in the statute that says that the public is allowed comment. So when you choose to give them the right to comment at a public meeting, you've now triggered the First Amendment. That's what we call a public forum now. And all those things I talked about apply. A public hearing is different because that's a statutory hearing and it has specific rules as to who has the right to be heard. And those people to have the right to be heard, you have to be in a butter, you have to have standing, you have to meet certain criteria. And because of that, the ZBA or the planning board can more strictly shape what's talked about. If people start to go off track or they start to talk about something not at all related to this land use, case or this variance, you can shut that down as a member of a land use board, for example.
Thank you. I needed to get that on the recording.
Yeah.
Appreciate you.
Yep.
You mentioned that the audience and so on, these meetings don't have a right to be heard unless there's a procedure for allowing people to speak, right? But you also said that the people in the audience have a right to be able to hear what's going on.
Right.
Okay, so what's the process? Because I think that happens a lot. People cannot hear because, for example, we can hear you perfectly, but you experience the talking in front of that microphone, and you do a good job at it. But during a lot of meetings when you have people up there, I say, inevitably, there's people that drift away from their microphone. You can't hear them, And right now, I think the procedure for handing that goes on very long. Somebody in the audience will holler out, "We can't hear you." But what's the process for making certain that we don't have to go through that process? What's your advice about that?
Well, I mean, I think for starters, you want to do the best you can to start off. So you want to make sure if you have the ability to have any type of microphones or audio amplification available so that people can be heard, you get started on the right foot. You can remind the audience at the beginning, if anybody is hard of hearing or is having trouble hearing, please don't hesitate to let somebody know. We can move you up to sit in the front row. We can remind ourselves to speak up. There's certain ADA compliance issues that you might come across, and for that, you really want to turn to your town policies and what audio equipment that you might have available to you. You do your best to make sure that everyone can hear, but if you don't know that somebody can't hear, right, then you're not doing anything wrong necessarily. And when you find out that somebody's having an issue, then you want to just do whatever you can to accommodate them, even if it's to pull a chair up so that they're sitting, much closer. So I think that's really the best advice that I can give.
One more question.
Yep.
What's the consequences of not properly giving notice at a meeting? Does that negate the meeting?
Yeah, so good question. The consequence of not properly noticing, the ultimate consequence really could be, yes, negating any decisions that were made at that meeting. So if you didn't post your notice with 24 hours or whatever it is, and you come to a decision and you vote on that decision, and somebody appeals or challenges that decision that was made, if notice was insufficient, then yes, a judge could overturn that decision. That is probably the most significant consequence that could happen. Short of that, it could be viewed as a violation of RSA 91A. And when you look in the statutes under RSA 91A:7 and :8, it talks about the remedies. Usually the remedies are something as simple as don't do it again. Sometimes it could be go to a training, or it could rise to the level of a criminal conduct if it's done deliberately. I mean, it wouldn't be the first time I've heard of someone trying to use notice to exclude someone specifically from a hearing or something like that. That's a whole nother story. But the most likely consequence would be you make a big decision and then it's overturned by a judge. All right, so let's jump into governmental records because this is equally as important and unfortunately a bit more complicated than what we've been talking about. So I want to make sure that we get to this stuff. So RSA 91A:4 paragraph 1, I think, is the most important paragraph in all of RSA 91A, and it also has caused some of the most issues because of the way that it was worded. What that first paragraph says is that any citizen has the right to inspect governmental records. The problem is that the legislature didn't give us a definition of citizen. So we don't know if they meant a citizen of the state of New Hampshire. We don't know if they meant a citizen of the United States. And nowadays, more and more, we don't know how to prove that a right to know request is coming from, never mind just a citizen, but even a human being. So that's a whole new, layer of issues that we're dealing with. And that ambiguity in the term citizen leaves a lot open for, what type of requests you do and don't have to respond to or provide records for. It can make it really tricky. And so the best advice that we have for dealing with that is to look at the rest of that paragraph, because it has the two most important sentences or lines, I think, in it. It says, every citizen during the regular business hours of all public bodies or agencies and on the regular business premises of such public bodies or agencies has the right to inspect all governmental records. And so notice it doesn't say that every citizen has the right to receive electronic records sent to them electronically. Every citizen doesn't have the right to have records printed out and mailed to them wherever they want. It says that every citizen has the right to inspect records on the regular business premises of such public bodies or agencies. And it's within that line, which thankfully still exists in RSA 91A, although for how much longer, we don't really know. But it still exists, and because of that line, you have the right to require that all people seeking to view public records do so in person on the regular business premises where they're kept, whether that's your town hall, your police department, your assessor's office, wherever those records live. If somebody makes a right to know request, your first step can always be, I'd be happy to provide you access to those records, make an in-person appointment to come and view those records. You don't have to do that. That's not a requirement under the law. That's just your best option. And the reason why I advise most municipalities to consider adopting that as a policy is because it's the only way that you can know that the person making this request is a real person. You can make sure that you are actually getting the records that they're requesting to them. And it also opens up a whole bunch of other important options that you have to protect yourself from those insanely huge requests that are asking for you to produce hundreds or maybe thousands of pages. And we'll talk about some of those practices that you have in a little while. But it's the most important sentence in RSA 91A, because if anybody says, no, you have to send me records, I want 4,000 pages worth of governmental records and you have to send them to me via my email, and there's nothing else that I have to do. You can say no. You can say RSA 91A:4 paragraph 1 says on the regular business premises, and that means that you have to come to my office to look at these records before I send them out to you. And that's the other most important thing I want to clarify. Once they've viewed the records, then you may have to send them to them electronically or give them paper copies, or there are a number of different ways that you could provide them with copies, and you may have to provide them with electronic copies if they want to. That also is probably the most economical way to do it. But before they've viewed the records in person, you don't have to send it to them immediately.
That's really good information. I was at a state meeting today and someone said that, but they always say, you're welcome to come in, let's make an appointment, and then they hardly ever show up. So thank you for saying that, because I didn't really realize we had the option to do that.
And that's one of the keys to this. So, we get, I'm sure you get them here. I think every municipality has got them. These requests come from, out-of-state businesses. Sometimes they come from educational institutions. Sometimes they are a piece of, AI software where somebody put in, literally they took 45 seconds to type in the name of a state, a whole bunch of records that they want, and they hit enter. And this computer program pulled every email address it could find on the internet for the state of New Hampshire and sent out a right to know request to every city and town in the entire state that the software could find an email address for. And these requests always ask for the records to be sent to them via email or whatever it is. And sometimes it's, again, thousands and thousands of pages. And that would be thousands of hours and however many thousands or millions of dollars that would cost taxpayer dollars paying administrative officials or local officials to gather these records and make redactions and consult with legal counsel, whatever it is, and then just send them off. And if you ask them to come and make an in-person appointment, 95% of those requests, you never hear from them again because they don't actually care about the records. They're doing it for predatory purposes. They're doing it because they want to help gather information for marketing purposes for their private business. And as soon as you ask them to come down to Londonderry, New Hampshire, you'll never hear from that person again. And it's not trying to restrict the public's access to public information. It's trying to simply protect yourself from having to spend countless hours and dollars doing something that probably doesn't even fit under the purpose of governmental records in RSA 91A, which is what we're going to talk about.
But just be careful because we have a policy, and we do email government records out to people because most people are responsible and they need things, they need them quickly. They don't have the time to come down here. Businesses are citizens, so we email them out. So we need to comply with our policy, and we go above and beyond what the minimum is required. We do get those requests from out of state, and I've had a 100% success rate. They want these very large documents. Pet food companies, they get dog licenses and all that other stuff, and there's a different statute on that. And we say, yeah, you can come here and get it, and every single time they don't come here and get it. And then we have some other people locally that'll go above what is necessary and ask for all kinds of things, which really ties up staff time. But most of our citizens don't do that. They need a simple thing. Hey, can I get a copy of this permit for my house? And we're going to email that to them. We're going to do it very quickly so they can go about doing their business. So just be careful. We have a policy, and we've got to follow it here townwide. So.
Right, and absolutely. So you should absolutely follow your policy. And the point of this sentence and the in-person requirement really does get triggered when we talk about those the pet food company that wants marketing information, or the lumber mill that's trying to get every single building permit that you've issued in the last 30 days with names and addresses because they want to target market or something like that. So your policy should cover that, and you definitely should follow the provisions of your policy. Yep.
So like the town has a policy that they email the records out at whatever the cost is or whatever. Do I still have a right to come in and look at it before that happens? I mean,
as a citizen?
Does it negate? I mean, just because the town has a policy that they'll email things out, doesn't mean I have to have them do that, right?
Right. I would say under RSA 91A, the statute does require that governmental records be available for inspection where they are kept at the usual place of business. So you do have to provide access, but there's also rules. You could have some policies for that, for how they set up access to view those records, and there's some statutory rules we'll talk about for when records need to be made available. But sending the records electronically it's an added service. It's sort of above and beyond. But there are retention and access requirements in the statute that have to be met for in-person viewing. Yep.
What if a governmental record is kept online, like in the cloud or something?
It still needs to be made accessible and available for viewing.
Would you still require somebody to come to the building during business hours, or I'm just trying to understand.
Right. Well, under your policy, there's instances where you would probably be able to just send that record. If you did want to have somebody come in for an in-person appointment for whatever reason and it fit within your local policies, then you could still show them that record electronically. It would be done on a computer or something like that where they would have access to it. Okay, so when you receive a right to know request, that request needs to be reasonably described. And what that means is that a municipal employee needs to know what it is that they're looking for. So if you get a request that's excessively broad, it doesn't include any information that would realistically allow you to even know what type of records you're looking for, that could be grounds for denying that request. But there is case law out there which essentially says that you have an obligation to try to work with these people to narrow down their request. So if you get that request that says, I want every email sent by every city employee over the last 20 years, that's probably not reasonably described enough to know what it is that they're looking for. What you would do in that instance is you would contact that person and say, listen, is there a specific person that you're interested in, a specific topic, a specific date range? You try to narrow it down in order to figure out what it is that they're actually looking for. If you're unable to, if they're not willing to work with you and you're left with a request that's so broad you don't even know where to start, then that could be grounds for denying it, but you should discuss that with your town attorney before making that decision. When you search for records, so you've gotten your record request, you know what it is that you're looking for, now the burden shifts to you to make sure that you're putting in a reasonable search to find those records. And so what that means, or the importance of that, is that the courts don't necessarily care if the record exists but was overlooked. The law cares that you looked in all the right places, and if you did so and you missed one or two records, then that won't be found to be a significant violation of the statute. But you need to make sure that you're showing that you engaged in a reasonable search. And so some of the advice that we give is to keep track of what you've done in the process of fulfilling a right to know request. So if you took 10 minutes to go through a box in the basement of some building looking for old records, write that down on a piece of paper or a spreadsheet or something. If you spent 2 hours going through an email server trying to find relevant emails pursuant to a right to know request, keep track of that, so you can have something to show that shows that you engaged in a reasonable search to find those records. When you are fulfilling a right to know request, you have to follow these 3 key steps. So the first is to determine whether or not it is a governmental record. Only governmental records are subject to the right to know law, and not everything constitutes a governmental record. Once you've identified the governmental record, you then need to determine whether or not the record or any portion of the record is exempt. And once you have your non-exempt governmental records, you have to make them available pursuant to some specific guidelines. So when it comes to governmental records, so what is a governmental record? It's defined in the statute. It's any information that's created, accepted, or obtained by or on behalf of a public body, a quorum or majority thereof, or a public agency in furtherance of its official function. And you'll notice included in that definition of what a governmental record is, it's information obtained by a public body. And a public body is, as we saw previously, even a committee, a subcommittee, or advisory committee. So that means that your advisory committees, when they are creating documents or they're accepting documents in furtherance of their official function, they are creating or obtaining governmental records. So the records of subcommittees also need to be retained and could potentially be produced pursuant to a right to know request. Most of the time nowadays, we see governmental records exist in all sorts of forms, especially electronic formats. So you want to make sure that everything, including email, voicemail, text messages, digital recordings, photos, information stored on cloud storage, that is all different types of formats that electronic records could exist in. I think one of the easiest ways to understand what is and isn't a governmental record is through an example, a couple examples that I have. So one of the questions I got was I had a select board member reach out and said, I sit on a 3-person select board. During one of the select board meetings, I received a text message. So I took my phone out and I looked at it and I put it away. And after the meeting, somebody filed a right to know request and they said, I want to know what he looked at on his cell phone during the meeting. And he said, do I have to produce a copy of that text message? It wasn't about the meeting. It was from my wife. She was having, a surgery or a procedure, and she wanted to let me know everything was okay. So do I have to produce that? So if we look at our definition of a governmental record, he didn't have to produce it because it fails in 2 ways. First of all, if we go through the list, it was information a text message is information, and it was created, accepted, or obtained by or on behalf of a public body or a quorum or majority thereof. There, it doesn't fit. It wasn't a quorum. It wasn't sent to two out of the three members. Even if you were one of those select boards where all three members are related somehow, maybe they all got the same text from their aunt or something that said, I'm fine from surgery, it still wouldn't meet that last piece, which is in furtherance of its official function. So the text message, my doctor's appointment went fine, isn't in furtherance of any select board official function. It's not a governmental record. It doesn't need to be produced. If we change the facts just a little bit, and instead that same select board member picked up his cell phone, looked at it, put it down, and received a right to know request. If the message he looked at was from the selectman sitting next to him that said, hey, Bob, I'm going to vote no on this motion. I think you should too. Then we go through the list, and all of a sudden we have a governmental record. We have information accepted or obtained by a quorum, 2 out of 3 select board members, and it's about the topic that they're going to vote on. So that would be an instance where you would have had a governmental record, and that would have needed to be produced. So next we're going to move on to exemptions. So we've identified that the records that are being sought to be produced are in fact governmental records. The next step is to find out whether or not any of those records are going to be exempt from disclosure. The law says that certain records always must be disclosed. They're never going to be exempt from disclosure. Those are things like employee separation payments if they're made in addition to regular salary or accrued vacation or sick time. Meeting minutes are always public record, and any lawsuit settlements on file with the town clerk must be made available for public inspection. Was there a hand over here? Sorry, no. Okay. There are several exemptions within the statute. RSA 91A:5 is the section on exemptions. There's a list in the statute of certain types of records that are going to be exempt from disclosure if they fall into that category. However, for the most part, it's going to require a little bit more of a detailed analysis as to whether or not the information is exempt. When you're deciding if information should or shouldn't be exempt, you do so with the understanding that the right to know law's purpose is to provide the utmost information to the public about what the government is up to. And if I could go back and edit this slide, I would put that in bold, because that is really the key to RSA 91A, is that the point of giving the public access to governmental records is to provide them with information about what the government is up to, not what other private citizens are up to, not what their neighbors are doing, not why were there blue lights at the house next to mine last night, I want to read that police report. That's not the point of RSA 91A. RSA 91A is to show what the government is up to, which is what we're going to talk about when we get to the privacy exemption. But nonetheless, when you do seek to avoid disclosure of information, you're going to say that information is exempt or it's not available under RSA 91A. You need to make sure that you are properly citing the reason for withholding that information. So you need to know you need to have an understanding of why information is exempt so that you can back up your decision to redact something or to withhold something. So RSA 91A:5 paragraph 4 is the paragraph that includes all of the main exemptions, including the most common one, which is the privacy one. So the first part of this statute talks about the categories of records that are exempt. So if a record is an internal personnel practice, confidential commercial or financial information, test questions, scoring keys, information used to administer a license or an examination for employment, academic examinations, medical records, welfare records, library user information, that is all exempt from disclosure as a category. So if anybody asks for information in one of those categories, for the most part, it's going to be exempt. And then it says, and all other files whose disclosure would constitute an invasion of privacy. And that's where we got probably 20 different New Hampshire Supreme Court opinions as to what it means to be exempt as an invasion of privacy. And through many different cases and many different pieces of case law, what we are ultimately left with is a 3-part test that the Supreme Court of New Hampshire has provided us. And the expectation is that when you are deciding whether or not you're going to redact information or disclose potentially private information, you need to have at least a basic understanding of what this test looks like. And what it says is, first, you have to identify whether information included in this record is potentially private information. There's a memo available on the Attorney General's website that lists all the types of information that could be considered private. It includes everything from somebody's name, address, phone number, email address, obviously things like their bank account information or medical information, information about their children or their employment status. All of that could be considered private information. So if that type of information exists on a governmental record, the next step is to ask what would be the public's interest in disclosing this information. And it's not, is one member of the public interested in this information? That's not the test. It's how would disclosure of this information give the public knowledge about what the government is up to? And then you have to balance those two interests and decide whether or not you should disclose the potentially private information. That's a complicated test, and it can feel difficult to understand and to apply. And so I think, again, the best way to sort of wrap your head around what this looks like is to use some real-life examples. So I've taken some examples of questions that we've gotten and just showed you how we worked through these particular questions. And I want to preface this by saying that the same person doesn't need to come to the same conclusion that we came to. There are different ways to interpret different scenarios, and what matters is not the outcome, but the understanding of the thought process behind it. So here's an example. This is one that we got where a citizen made a right-to-know request for all building permit applications filed with the town in the last month. And he wanted the name, address, and the information about the project included on the building permit. And so the building official contacted us and said, I don't know if I feel comfortable giving this person the name and address of everyone who's about to engage in a home improvement project. That just doesn't feel right to me. Do I need to provide it? And so we went through that public versus private balancing test, and we said, well, somebody's name, especially when it's linked directly with their address, is something that a regular person would consider to be somewhat private. It's not the biggest privacy interest, but it definitely is a privacy interest. So what would be the public purpose in releasing that information? And what we concluded is that the public purpose or the government function behind building permits is making sure that the municipality is issuing the building permits correctly, that they're going through the permit process fairly, that they're approving or denying projects correctly under the zoning ordinance or whatever it might be. And to understand that government function doesn't require the person's name and address. It requires the description of the project, whether the permit was approved or denied, maybe the time when the permit was filed and when it was approved, the time it took to get it approved. All of that gives the public information about what the government is up to. So we said you could reasonably redact everyone's name and address from those building permits and provide everything else. And that's what they did, and it ended up being a good call, I think, in this situation, because the person making the request was the owner of a lumberyard, and what they wanted to do was they wanted to target advertise to all of the people who were about to engage in a home improvement project to buy lumber from them instead of their competitor within that 30-day period. And of course, that wouldn't be the purpose of RSA 91A. So I think that was a reasonable decision to come to. But if we change the facts just a little bit, and we say that the town got the exact same right-to-know request, they want all the building permits filed in the last 30 days with the name, address, and project information. And when the redacted building permits were provided, let's say that the requesting party said, well, I really need the address because the purpose for making this request is that I think that the town is discriminating against certain subdivisions. I think the lower income houses are not being given the same, issued the same building permits that the people who live on the rich side of town are getting. And that's a discriminatory act that the town is engaging in their building permit issuing process. Well, with that additional information, now there may be a compelling public interest in releasing the addresses. I still don't think the names are particularly relevant, but that might be a reason to then provide the address and with the rest of the information in the building permit. So that's just a little example of how you might see different information become redacted or unredacted based on the type of request that you received. Another example, we had a town that published their assessing records on their website, that anyone with an internet access could access those records. That's not required by law. The law requires you to keep assessing records, but not necessarily post them on your website. There's nothing wrong with doing that, but a local police officer contacted the town in this instance and said that they were a little bit concerned with how easily people could find out their address, especially because they were a police officer in town, and they wanted to know if their information could be removed from the website. And so, again, we applied that public versus private balancing test and concluded that there wasn't any particular reason why the assessing records needed to be published on the website, and that we have somebody with a legitimate privacy interest. And I think there are a number of different reasons why somebody could have a privacy interest in that information, not just being a police officer. But it was enough to say that if the town was willing to do so, they could consider taking that record off the website. And that's what they did. And then there was a follow-up request. The person said, I appreciate you taking my information off the website. I'm now curious if you could redact my name and address, or at least my name, from the actual assessing record itself, the one that's available at Town Hall for inspection. And so we applied the exact same public versus private balancing test, but here there's a little bit more of a compelling public interest at stake, because the public has a right to know that the government is fairly assessing taxes. And in order to do so, that may require an unredacted and intact assessing card. This information is also available elsewhere, like at the Registry of Deeds, and the individual had other tools at their disposal to protect their name and address if they really wanted to, like putting their property in an LLC, for example. So at that point, our advice was to not further redact anything else off of the assessing card, that there was a compelling enough public interest to overcome the relatively minor privacy interest in somebody's name and address. So those are two examples of how you might apply that public versus private balancing test in a real life scenario. Any questions on that before I move on? Yep.
How appropriate is it to ask why they want the information? What public, how is this going to serve public knowledge of what's going on?
Yeah, so that's a great question. So I usually get this comment when I talk about this. Doesn't RSA 91A specifically say that a person's motive for viewing public records is not relevant to whether or not you should provide the record? And that is true, that the law does say that you cannot take somebody's motive into account when deciding whether or not you should give them access to public records. If the record is a public record, they can have access to it no matter what they want to do with it. Even if they want to post it on their Facebook page and use it just to smear the local officials, they can do it if it's a public record. But the key here is that before you determine whether or not the record is public or the information is public, you have to go through the public versus private balancing test that the court gave us. And inherent in that is the necessity to ask, in certain instances, what is the compelling public purpose in releasing this information? Or maybe another way to put it is to say, this information is redacted under the private versus public balancing test because at this point there is no identifiable compelling public interest which would justify releasing it. And at that point, I would argue that the burden shifts to the people making the request to then provide more information that might allow you to adjust the balancing test and provide more access to that information. So I think you can ask why during the course of determining whether the information is even a public record or public information or not. And there are sort of different ways that you can handle that, but I definitely think you can do that. Drafts and notes. So drafts of documents that have not been set in their final form or disclosed or circulated to a quorum of a public body for discussion are not subject to disclosure. Once they've been finalized in their final form, then that would be the governmental record. And any personal notes that might be taken on margins of a document, or if you take notes yourself during a meeting, those are not subject to disclosure under RSA 91A. Law enforcement records have additional protections. Not only are law enforcement records protected under the normal exemptions in RSA 91A, but they're also protected under the FOIA standards. FOIA stands for Freedom of Information Act. There are several factors which would also protect information from being disclosed, like if it would interfere with law enforcement proceedings, interfere with a fair trial, constitute an invasion of privacy, reveal confidential sources, disclose investigative techniques and procedures, or endanger life and safety. And so I have one more practice example here for law enforcement records, because we see this one a lot. An attorney who represents someone in a divorce proceeding, maybe they don't even say what they represent them in. They just say, I represent so-and-so. I'm seeking all records of police responses or involvement at this particular address. And they don't give any additional reason. They just say, I want to know every time the cops were called at this particular address and all the reports that were generated from it. There's no public interest at play here in releasing that information. This would be an example of an attorney essentially trying to use RSA 91A to dig up dirt on a private citizen, which is, again, not the purpose of RSA 91A. Furthermore, the courts have ruled over and over and over again that citizens have a huge expectation of privacy when it comes to their interactions with law enforcement. So when you get that request of, I want a copy of the police report from my neighbor's house because I saw the police respond there last night, that information is almost always going to be not available. It's going to be exempt under RSA 91A:5, privacy exemption. There would have to be some other indication of a much more compelling public interest that would warrant violating somebody's privacy interest in that information for it to be released.
So when police respond to like an overdose or something to that effect, like when you say not disclosed, do you mean like, do you send like a fully redacted, like I, Lieutenant Cruz, responded to such and such an address and such a date, and then redact the rest of the privacy interest?
Yep.
Or do you just say this entire report is being withheld?
I think it can depend on how the request is made. So, for example, if the request is, I want to know, I want a copy of the police report from the interactions last night at 123 Main Street. They and let's say that actually exists, right? There was a police call to that address. So this person obviously knows that the police responded to this address. That particular portion is not so private because anybody driving by can see that there's police cruisers in front of this particular address. So in that case, you could provide just the record that the police were dispatched to this address at this time and all the other interaction information redacted. That would be a little bit different than somebody saying, I want all records of police investigations into so-and-so, John Smith or whatever. They may not know if there are any. And the fact that you say that there even is records related to this person could be, an issue in and of itself. So when there's been no information provided that would indicate that there's knowledge that something actually occurred, that might be a scenario where you would say there are no governmental records that would be available to you related to that issue, and to the extent that there are, they would be protected under RSA 91A:5, the privacy exemption. So it depends a little bit on like the form of the request. Yep.
If the police department releases like a police blotter to the newspaper, does that change any of that public versus private information?
Well, it doesn't, except to the extent that what the police put out there, on the blog or on the Facebook page or whatever it is, that is public information, but it doesn't then erode the person's privacy interests in whatever interaction they might have had with law enforcement. So in this instance, there would likely be no reason to provide access to those records. There is a small carve-out to this, which says that if somebody's life or safety is at risk and they or someone that they are responsible for, information can be released to them on a limited basis to protect that life or safety exemption. And so if the person making the request was a caregiver or a guardian or a parent, and the person whose information was contained in the record was their child or someone that they were legally responsible for, then you could potentially provide them access to that information, although information about anyone else involved would still have to be redacted. It's only that person whose specific health or safety is at play that you would be able to release it to. Yep.
2 slides ago it said, FYI, there are other ways the attorney can get the info. What
Yes.
do you mean by that?
So I put that in there because I've just seen this more and more. I think there's a trend that I'm seeing among maybe some attorneys and particularly perhaps public defense offices that think that RSA 91A is the avenue to get records related to their case or to their clients that will help them in defending their clients, and it just isn't. It's not the purpose of RSA 91A. They can still get access to those records, but they need to do it through a court order or through discovery or through whatever other means they can get access to these records. The key is 91A is a public record request, which means if it's available to one member of the public, it's available to every member of the public. So it doesn't matter that I represent this person and may be entitled to this information for one reason or another. If I'm making the request as just a public records request, or I don't have any other legal agreement or legal right to view those records, what I'm basically saying is that if you give it to me, then any person who walks in off the street can also obtain those documents. So there's more than one way to get access to a record. 91A is not the way in that instance. Information that would provide someone with the ability to circumvent your IT security protocols is also exempt. So you can anything that would potentially open you up to like a cyber attack or something like that is exempt from disclosure. Information that's protected under the attorney-client privilege is exempt. So that is still a blanket exception for all records that are protected under the attorney-client privilege. Once you have collected your governmental records and you've reviewed them for any potential redactions or exemptions, your last step in complying is making those records available. And so there are a few basics that you have to follow. So records only need to be provided immediate access to those records. And what I mean by immediate access really is upon request, is when they are immediately available. And so what I mean by that is that not all records are immediately available. You might have to search for certain records. You might have to review certain records. Those are not immediately available, which means you are more than entitled to ask for more time to search for those records. The records that are considered immediately available are things like meeting minutes. Those are not going to be redacted. They're not going to be exempt. They need to be made available upon request. But the court has also recognized that the right to know law does not give citizens the right to review records in any quantity and wherever kept immediately upon demand. You have the right to require an appointment to view records so that you can manage your day around these record requests. People can't just walk in off the street and demand, hijack your time. You have to drop everything you're doing and respond to them. The law recognizes that you have the ability to ask them to come back at a later date so that you have time to prepare for providing those records. The right to know law also doesn't require you to compile information for people. And what that means is that if I want to know specific information about something, and that information exists in a whole bunch of different governmental records, you don't have to do the research for me. You can give me access to those records, and I'll comb through it to find the information that I want. Sometimes it's actually easier for you to compile records for that person. It requires less, footwork for you, which is fine. Especially now with the use of software and even AI to quickly identify information that's located within electronic records, you might be able to resolve a record request quicker by compiling information for someone. But you can't be forced to do it if you don't want to. Someone can't force you to sort of do the research for them. You cannot charge flat fees for records. The fee associated with providing somebody access copies to records has to be reasonably related to the cost of actually producing that record. So paper costs, ink costs for printed pages, 10 cents per record, 50 cents, something like that. If you have to put information on a flash drive or a CD, you can charge for the cost of that. I think you have a policy on costs for producing copies, which should handle the work for that. But just know that it can't be a flat fee. You can't say for $5 you get access to this record. It has to be related to the actual cost of making copies.
Question.
Yep.
So you're not able to include time and labor that the town had to spend?
You are not.
To the attorneys and to their own staff?
As of right now, New Hampshire is one of the only states, at least in New England, that has no provision to charge for time and costs in exactly what you just said. You cannot charge people anything to access the records. You can only charge them to receive the copies of those records. They have to be allowed to view them for free. With one exception for massive electronic communications, which I think I have a slide in here on it, but if I don't, there was one small change. It essentially says that any request for electronic records that exceeds 250 separate communications, you can charge someone $1 per communication over 250. So if I made a request for 10,000 emails that I wanted access to, after you reviewed the first 250 or found the first 250, you could charge me $1 per communication for everything after that. But that's the one exception. For everything else, it's not, you can't charge for time. A note about electronic records. So if records exist in an electronic format, so they're a PDF, they're an email, they exist on a computer somewhere, and somebody wants a copy of that record in an electronic format, you do have to give it to them electronically. You can't, the reason for this is you can't try to force someone to pay a fee. So if they say, I want you to send me the records, I want you to send me these emails electronically, you can't say, no, I'm going to print every single one out and charge you $1 per page. You can't do that. You have to send it to them electronically. When it comes for time to produce records, the statute says that you have to provide an answer within 5 days. But an answer doesn't always mean the records. It can mean a number of different things. You could provide access to the records within 5 business days, and you'd be in perfect compliance with the statute. You could also say that you need additional time and ask them, give them a timetable. It could reasonably take you 10 days, 30 days, 60 days, 90 days, whatever it is. Whatever reasonable amount of time it's going to take you to find these records, you can ask for that. But you need to respond within those 5 days, and you need to provide in your response a reason for the delay if it's going to take you longer than 5 days to provide access to those records. So you want to make sure that in that 5-day window, you're responding to the request. That doesn't necessarily mean that you're providing access to it. Record retention and remedies. So you have an affirmative responsibility to keep municipal records for as long as required. RSA 33-A:3-a contains 156 categories of records that need to be retained. And it tells you how long you need to keep them for. Some of them are as long as needed, which could be as little as 5 days, 10 days, 30 days with something like regular email communication. Once that period is up, you can then delete those records. It could be as long as forever, like with meeting minutes. So you want to make sure that you're complying with those statutory time limits. For electronic records, when you are deleting records because they no longer need to be kept, you need to make sure that you're deleting them from all the places that they might live. So deleting an email out of your inbox doesn't delete that email forever, right? It's sitting in your deleted folder. Deleting the email from your deleted folder on your inbox doesn't delete it if it was backed up to your IT's cloud backup server. It still exists there. So you want to make sure that when you're deleting things all the way, that they don't exist somewhere else, because if they do and they're recoverable, you might be expected to recover those records and produce them. You are allowed to convert paper records into PDF to create an easier way of storing governmental records, as long as you're following the proper statute to keep them in PDF-A format. You're allowed to turn all municipal records into electronic records for storage. Violations of RSA 91A are enforced in a number of different ways. At one point, we had the right to know ombudsman, which was a individual office, and he was an expedited sort of arbitrator of right to know issues. That office is no longer staffed right now due to a funding issue, so we don't know if it'll be coming back or not. An aggrieved person is someone who is allowed to file a complaint. There's not a strict definition of what it means to be an aggrieved person. That would be a decision for the judge now to determine whether or not somebody meets that requirement. And so without the ombudsman's office in functioning, the real remedy is to file a lawsuit with the Superior Court. If there's found to be a violation of RSA 91A, there could be attorney's fees or costs issued by the court. It could invalidate the action of a public body, like if you didn't meet proper notice, like we talked about. There could be civil penalties, injunctions, remedial training. If you knowingly destroy records, that could be a misdemeanor. And attorney's fees can be awarded either way. So if a citizen makes a frivolous complaint against your town, the judge could make them pay the town's attorney's fees. Most of the time, it goes the other way, unfortunately. So with that, that does conclude everything. I know this was a lot of information, so thank you for sticking with me. I'll stick around if there's any additional questions, but thank you for having me, and I hope this was an informative presentation.
We'll be sending out the right to know manual that they have. We'll be downloading that, the latest version, and we'll send it out to everybody so you'll have that as a reference document.
Don't forget there's an attendance list.
Yeah, it's right here. If you could just sign up.